Hello, and welcome to Podcast Bites powered by INDIALAW LLP. I'm Brian Noronha, and today we unpack a ruling of the Honorable Supreme Court that clarifies the interpretation of Hindu maintenance law. The Honorable Supreme Court has held that a widowed daughter in law can claim maintenance from her father in law's estate even if her husband dies after the father in law. Let's dive in. On 13th January 2026, a division bench of two learned judges of the Honorable Supreme Court, whilst dismissing two civil appeals, has held that a daughter in law can claim maintenance from her father in law's estate, even if her husband dies after the father in law, and by doing so, has interpreted the provisions of sections 21 and 22 of the Hindu Adoptions and Maintenance Act 1956 in a manner that is beneficial for widows. The factual premise is as follows. Dr. Mahendra Prasad, who had three sons, Ranjit, Devinder, and Rajiv, had executed a will in 2011 favoring the children of his predeceased son, Devinder, and daughter-in-law, Kanchana. When Dr. Prasad expired in December 2021, two sons survived him, Ranjit and Ranjiv, as well as Devinder's widow, Kanchana. Ranjit passed away subsequently in 2023, and his wife, Geeta, now a widow, immediately filed an application claiming maintenance from her father-in-law's estate from the respective family court. The family court, however, dismissed the maintenance application by holding that she was not a widow on the date of the death of her father-in-law, and thus she would not be a dependent under the Maintenance Act. The Honorable High Court, in appeal, reversed the decision by holding that Geeta is included as a dependent since she is a widow of one of the deceased sons, and thus the maintenance application would be maintainable. Being aggrieved with the decision of the Honorable High Court, two civil appeals were filed before the Honorable Supreme Court. At the heart of the dispute was a core legal issue, whether a daughter-in-law who becomes a widow after the death of her father-in-law would be entitled as a dependent to claim maintenance from the estate of her father-in-law. In order to delve into the issue, the Honorable Supreme Court proceeded to undertake the interpretation of the provisions of the Maintenance Act. It was first observed that the term dependents has been defined under Section 21 of the Maintenance Act, wherein subsection 7 includes the relative of a deceased being any widow of his son as a dependent, which is qualified by the phrase, so long as she does not remarry, and provided to the extent she is unable to maintain herself from the estate of her husband, her son or daughter, or herself, as the case may be. After observing the words found in the statute, the court held that the definition of the word dependence was clear and unambiguous, and it would mean any widow of any son, whether such son is predeceased or not. The court reiterated and referenced the cardinal rule of interpretation. Where the provision is unambiguous, the literal interpretation ought to be adopted, provided that there is no conflict with the object or the purpose of the Act. The court referred to the decision of the Privy Council in Crawford versus Spooner to reiterate that courts are not permitted to add or mend words found in a statute unless the same is necessary in the context or the preamble of the statute. The court further referred to its own decision in B. Premanand versus Mohan Koikal, where emphasis was placed on following the literal rule of interpretation, since, as per the constitutional scheme, the domain to legislate upon is with the legislature. Finally, the court referenced its recent decision in Vinod Kumar versus the district magistrate to state that judges cannot supply words into a statute, as the legislature is presumed to have intended what is expressly stated. Thus, the court interpreted the language used in Section 21, Subclause 7 of the Maintenance Act to hold that it means the widow of any son, not any predeceased son, would be included in the term dependents. Secondly, the court held that by interpreting the words of the provision as above to mean the widow of any predeceased son would be violative of Article 14 of the Constitution, whereby the courts would be distinguishing between widows on the basis of when their husbands had expired, and that has no rational nexus to the object of the Maintenance Act, which is to provide for protection of the vulnerable. Third, The court also relied upon principles relating to Article 21 of the Constitution by stating that the livelihood and basic sustenance is included within the right to life, and forcing a widow to fend for herself when the estate can afford the maintenance would not be permissible under the fundamental rights enshrined in the Constitution. Finally, the court relied upon the provisions of Section 19 of the Maintenance Act, observing that while Section 19 provides for maintenance to be provided by the father in law to the widowed daughter in law during his lifetime, Section 21, paired with Sections 22 and 23, provide for the maintenance after the death of the father in law, and the right to the maintenance of the dependents to be claimed from the father in law's estate would arise after such death. The Honorable Supreme Court thus dismissed both civil appeals and directed the family court to consider the maintenance application on its merits in accordance with law. The larger effect of this decision is that the estate carries with it a charge in favor of statutory dependents as enumerated under Section 21 of the Maintenance Act. And although one may opt to disinherit dependents via testamentary instruments, the right of maintenance cannot be taken away. Interestingly, the court briefly invoked and referred to Manusmriti whilst quoting that blameless relatives cannot be forsaken, showing that codified law still breathes through the ethic of pious obligation. If you found this useful, hit follow and share. Drop your questions at contact@indialaw.in. Our team of partners loves unpacking your hypotheticals. That's a wrap. I'm Brian Noronha reminding you that although the law is complicated, understanding it doesn't have to be. Until next time, stay curious and keep it legal.